Okay, a very good morning to everyone present here today, and welcome back to the second day of the workshop on intellectual property rights. On behalf of the SCAC Center for Innovation and Entrepreneurship, I, Astha Kumar, am very glad to welcome back our esteemed speaker for the day, Mr. Gokul Narayan sir,
Thank you.
who is here to
Thank
guide
you.
us on the topic of intellectual property rights. Sir has joined us from Delhi, and we are very grateful to you, sir, for sharing your expertise and your time with us. I would like to welcome our principal, Dr. Rishikesh Soman sir, our Vice Principal, Dr. Tessie Thadatil, Head of Department of Business Laws, Dr. Swati Chine, Head of Center for Innovation and Entrepreneurship, Dr. Sharayu Bhakre, the Professor in charge of this program, Dr. Nilesh Wagmare, and all the faculty and the students of our college for the second day of this workshop. The workshop on intellectual property rights is organized by the Center for Innovation and Entrepreneurship with the Department of Business Laws SCAC and has been possible because of the RUSA funding received by our college for entrepreneurship and skill development. I would like to reiterate that the Center for Innovation and Entrepreneurship of our college endeavors to foster an entrepreneurial ecosystem in the college and provides the students with a platform for starting their own ventures. The college has also constituted the institution's Innovation Council as per the guidelines of Government of India's Ministry of Education with a vision of infusing innovative and entrepreneurial acumen amongst the students. This two-day workshop commenced yesterday, that is on the 27th of January, wherein Mr. Gokul Narayan sir gave the attendees an in-depth perspective about the relevance of intellectual property rights and its types, ranging from patents and copyrights to trademarks and designs. Today, the workshop will be focusing on fundamentals of copyrights, the significance and application in the real world, followed by an extensive interaction with the participants. We have the immense pleasure of having with us here today our respected principal, Dr. Rishikesh Soman sir. I would like to invite sir to speak a few words.
Thank you. Thank you, Asta. Uh, Good morning, everybody. Good morning, Gokul. Yesterday, I couldn't attend your program because I was busy with another program. But nevertheless, better late than never. So, welcome back again to Symbiosis College of Arts and Commerce. I know you're a very good teacher, and I have seen students getting mesmerized in your classes, and because you may have heard the student that he is being associated with us almost for last 13 14 years, and he has been a very good teacher of cyber law in our liberal arts. So welcome back again, and I'm sure that we will be able to get immense benefit out of your insight and your this thing. I would suggest that if possible, I mean, if not in this lecture, but in general, if you have any kind of SOP material kind of thing, procedure, that if I want to file a copyright, then step by step procedure, or patent, then step by step procedure. If you have that kind of material,
I
yeah,
I can make it and send it across, sir. What I intend doing in the class today is during our interaction, show them a little bit of that procedure in terms of different kinds of copyright that needs to be filed. Patent is far more complicated. You need to go through a
yes,
patent
yes,
agent.
yes,
But copyright, I intend showing it to them. But what I will do
right,
is, sir, I'll create a system of application and I'll create a small document and I'll share it with Sharayu ma'am and
right,
she can share it
right,
with the students, sir. I can do that and send
right,
it. It's not a problem.
right, right. Because as you know, we are basically humanities and commerce students, so
Sir,
we will be more requiring copyright than the patents, because
correct, sir.
I don't know how many patents we will be able to generate, but copyright certainly yes. So if we
Absolutely.
can have a kind of, because many times it happens, including me, to be very frank with you, where to apply? I mean, if I want to apply for a copyright, where to apply? What is the procedure? Where is the form? All those basic details are also not available very easily, or at least we, since जिस गांव को जाना नहीं उस गांव का रास्ता क्यों पूछे, ऐसा होता है थोड़ा सा.
Correct, sir.
So
Correct, sir.
naturally we have not really got into that thing, but then since we have now it is time that publish or perish, as well as create intellectual property right of educational institution. I believe that it is important to have these kind of standard operating procedures laid down and available in the college for everybody's benefit, so
Correct,
that
sir.
anybody who has got a good idea can immediately apply, and through college or through concerned teachers guidance, the student should apply, and a student or teachers or anybody for that matter, and
Sir,
that would actually be benefited for the college. So if you can simplify, and if you can put it in various steps, step 1, step 2, step 3 kind of thing, that would be of a great help to us.
I will do that, sir. I'll create that document and I'll send it across to Shariu, ma'am. She can share it with everybody, sir.
Sure. Thank you,
Absolutely.
Gokul. So I will not take much of your time because students are eager to listen to you. And today is again, as I said, more relevant topic for us than patent, because we may get into more of copyrights. So please go ahead. I welcome you once again, and I thank you for sharing your time with us. Thank you.
Thank you, sir. Thank you so much.
Thank you.
Thank you so much, sir. Now, for those of you who were unable to attend yesterday's session, it is my pleasure to say that we have with us our very own Mr. Gokul Narayan, sir, who will be conducting today's session. He is an educator as well as an entrepreneur, having immense expertise in information technology law and intellectual property law. Mr. Narayan has pursued his master's in law from Symbiosis Law School and is currently working as the Chief Operating Officer at the Asian College of Cyber Laws. He has had an illustrious career spanning over 16 years, throughout which he has worked with numerous prestigious organizations like the Knowledge Exchange Institute in New York, the Symbiosis School of Liberal Arts, and Data 64 Techno Solutions, to name a few. Mr. Narayan has also curated and conducted courses on cyber law, intellectual property rights, tort law, and legal awareness. We kindly request all of you to remain with us throughout the duration of the workshop so that you do not miss out on any important updates. Please note, for the process for availing your certificates will be communicated as we progress through the workshop. We heartily encourage questions from the audience. Now, without any more delay, I invite Mr. Gokul Narayan, sir, to commence the workshop. Sir, we can take a break of a few minutes as per your convenience in the middle of the session. Over to you, sir. Thank you.
Thank you, Asta. Asta, just one question. Will you be coordinating? Because I'll need some videos and some content to be shared. So may I send it across to you via chat, and then you can share it with the rest of the group if you could do that.
Yes,
sir. Could you just send me a chat message so that I can share the? I'm not very well versed with Teams, so I've struggled with what the interface looks like. So if you can just send me a, where is the chat option over here? I can see emoticons. I can.
ऊपर है
पर वो तीन डॉट्स पे क्या सर?
नहीं, उसके बाजू में देख.
Sir, you will see a chat bubble next to the people icon.
मिडल ऊपर मिडल पे 3 डॉट के बाजू में.
सर वो शेयर कंटेंट का है सर.
नहीं, शो कॉन्वर्सेशन है ना.
Sir, to the left.
I think my interface is a little different. I don't know.
तो क्या एप्पल यूज करता है क्या?
नहीं सर, मैं इस पे हूँ, माइक्रोसॉफ्ट इस पे हूँ. I've got a.
Okay.
I don't know. We'll figure it out together. In any case, so this is the oxymoronic situation that I perpetually find myself in. I teach technology and I'm very, very technologically challenged. So in fact, my 70-year-old mother is far more astute while using technology than I am. And so is my 8-year-old son. I'm just stuck in the wrong place. I apologize, but we'll figure out how I'll communicate.
You can share it via WhatsApp with Varun. I think he's been chatting with you. So
fair enough. I'll do that. I'll share it via WhatsApp with Varun and he can put it up. So we can show a short video and certain audio clips and all that. We can do all of that, right?
Yes, sir.
Great. All right. Thank you.
Thank you.
Asta. Hello.
May I begin?
Yes, sir. Please go ahead.
All right. Good morning / good afternoon, everyone. Thank you so much for joining back. I'm going to begin very quickly because there's lots to cover. And I'm sure all of you will have a lot of questions and hopefully I can answer all of them. So let me begin very quickly. What I'll do is I'll do a very quick overview of what we did yesterday in terms of types of intellectual property, then jump right into copyright. So I'm leaving copyright aside. I'm going to very quickly discuss the other forms of intellectual property. It's very important to understand the other forms to be able to get a complete grasp of what copyright is. So let's begin with trademarks. If you remember, trademarks are a system of intellectual property which have been created with the sole purpose of making it possible for customers to remember brands. The purpose is brand recall. So it's a logo, it's a combination of colors, it's a symbol. The purpose of such logo, symbol, ticket, label, sound, smell is to help customers distinguish between products of a similar nature. Now, I say this because there are certain parts in which trademarks and copyrights seemingly tend to confuse people. Like, for example, you can't copyright a name. So Sachin Tendulkar cannot go and copyright his name, however famous he becomes. However, Shah Rukh Khan and Tendulkar and Amitabh Bachchan can trademark their names. So you need to understand the difference between them. Although they are words and they are written in a particular language, they still cannot be copyrighted. They can be made subject to the form of trademark. Therefore, trademark is basically helps customers distinguish between products of a similar nature. And if the person becomes a brand, like for example, Gucci, if you've seen the House of Gucci, you'll understand what I'm trying to talk about, or Jimmy Choo. All of these are individuals who made a brand out of their own name. These can be trademarked. So helping customers distinguish between products of a similar nature. And for that, if you remember the examples that I've given you of Coca-Cola, salt, jeans and things like that, or the very basic forms of mobile phones or the smartwatches that people wear. I'm just looking at the smartwatch. If I don't switch it on, it's very difficult because most of them look like this now. So it's very difficult for an average individual to find out which brand this belongs to. All right. Now, also the fact that domain names and their extensions fall within the category of trademark. So if there is a domain name dispute that takes place, it can be covered under trademark law. Although there is a different law, which is called the Domain Name Dispute Resolution Policy, which is also in place, but that's not something that we need to go into right now. You need to understand that domain names are a part of the trademark regime. One. Secondly, we come to designs. Designs basically are a form of intellectual property which help distinguish products from a visual appeal. So, for example, the design of this glass, which has got, I think it's I don't know what kind of a glass it is, but it's got a design on it. The manufacturers of this glass, they can go and register this design, saying that our design is unique and it can be visually distinguished from other designs, and therefore it needs to be protected. Now, if you look at any bottled water company, for example, Aquafina registered that design, Bisleri registered that design, Manikchand Oxyrich registered that design. Of what? I'm not talking about the contents inside the bottle. I'm talking about the look and feel of the bottle, different from other bottles. So Coca-Cola has gone and registered their design for the glass bottles were registered. I need to check whether the plastic PET bottles are also registered under the Designs Act. The glass bottles were registered. So designs basically help distinguish products on a visual basis and helps distinguish between them. The confusing part about this is the fact that when you get a design registered, and please remember, unlike copyright, you need to apply for a design for it to be given to you. It inherently does not exist. But, and please don't get confused, and I'm saying this very simply, when you are granted a design, the words used under the law are you get a copyright in design. So the word copyright actually appears in the design. In the design law as well. So don't get confused. It's just a nomenclature used to explain the rights that are vested upon you. Okay, so this is the designs. Now we come to geographical indications. Geographical indications are indications which help get recognition for a particular community because of the unique product that they produce. Now, the exciting part about this is that, for example, I have to remember Delhi University has applied for a geographical indication for I think they're the registered, what do you say, subscribers for, if I'm not wrong, it is the Kolhapuri Chappal. So as a university, as a college itself, you guys can apply for a geographical indication. Although it will belong to the community, you can be the organization that makes the application for the registration of such geographical indication. That's possible. So if any of you are interested in making an application like that and have identified a unique product from a particular place which you think deserves the recognition as a geographical indication, I can help you get that registered. It's a feather in the cap of the institution also. So please remember, the purpose of a geographical indication is to get recognition for a community for the unique product that the community produces. So the examples that I gave you yesterday were Kolhapuri Chappal and Puneri Pagdi. You remember the Pagdi, which is a part of the Maratha Empire, and post the Holkars, the Sindhyas, all of them had this Pagdi, which had it's a cross-beam pagdi with a pearl hanging, a set of pearls hanging from the top. I've seen the red version of it. I haven't seen other versions of it. But if you go to Shaniwar Wada and in the museum that is associated with the Shaniwar Wada, they've got some of these pagdis kept over there. You should go and have a look. And that's a geographical indication that has been given. So a particular place producing a unique product, and the combination of the two is given a geographical indication. What you need to remember about this form of intellectual property is the fact that it can be a manufactured good, an agricultural good, or a natural produce as well. So it can be given to something like oranges, it can be given to something like a petha or a peda, and it can also be given to cloth which is manufactured. For example, you can give it to, like I told you, silk. Most of the silks around the country are registered under the Geographical Indications Law. So community, unique product, the combination of the two can be protected. The next, and this is where we need to start focusing on what copyright is and what its distinction is. Patent law. Patent law specifically and only applies to technology and technological advancements made. It does not apply to anything else. Scientific invention. What you need to remember about patent, however, is that it is given for an idea, but it is not given for an idea the execution of which has not been figured out. For example, there is no patent for a time machine. Although it exists as an idea, there is no working model in place. So to say that it is available for an idea or an idea can be patented is accurate, but you must understand it in its completion. That idea must be capable of industrial application. So if you can create only one of a kind and you can't apply it to an industry, you can't patent it. मतलब दूसरा उस चीज उस तरीके का दूसरा कोई product आप बना नहीं सकते हो. It's not possible to make it. For whatever reasons, I do not know what the reasons could be, you will not be able to get it patented, because at the end of the day, the purpose of such information is so that other people, after the period of patenting is over, can manufacture or create the same thing and benefit from it. So something which merely exists as a concept or an idea cannot be patented. It needs to see the light of day, or now, or at least in the possible near future. Even if it is possible in the near future, you can apply for it. Like, for example, pharmaceutical companies very often apply for patents before the final drug is released into the market, because the testing is going on. So they apply for the pharmaceutical the patent for the pharmaceutical product. Before the final trials are also complete, they apply for it, because conceptually the idea is ready. Whatever they are hoping to achieve through that drug is already been achieved. All they are going to do is testing now. So it need not be in the form of a finalized product, but it has to be something that has the possibility of completion in the near future, or should have already been completed. But in patent, there are two concepts that you must always remember. The first, that patents are, sorry, three scientific inventions which are the ideas of which can be patented only if they are novel, new, hitherto before unseen, unheard of. So even if I apply for a patent and you can produce one document which is prior to my date of application for patent, which says that this idea I already know, this is something that already existed, you cannot patent it. So prior art, prior existence of technology or knowledge will will get your patent rejected. Also, patent cannot be given for an obvious improvement in technology, something that any person who's a part of the system could have obviously guessed. For example, one of the side effects of painkillers is acidity. Now, if you create your composition of the painkiller is same as the existing product which is there in the market, but what you do is you add an antacid into the formulation of the acidity instead of having it separately. So generally they say have this medicine, have an antacid along with it. But what you've done is you've combined the antacid with the brufen. It's not an advancement in technology. It's something which is obvious, will not be patented. I don't want to complicate things too much, but these are the basic concepts of patent. So remember, scientific invention, it has to be, for the protection of an idea which is capable of fruition or can see the light of day or can be executed through an industrial process and has to be novel. Now, why I'm insisting on this concept of novel so much is because it's confusingly similar to the idea that we're going to talk under copyright. And therefore, it is very necessary for you to understand what new means. Before, it has not been seen. All right. Now we come to a new concept, which new idea, which we had not discussed before, but which is very important to understand why forms of intellectual property exist in the manner in which they do today in India and the world over. Now, the digital era, there are cliched dialogues that people say, like the world has become a global village and things like that because of the advent of technology and the World Wide Web. And you physically need a passport to travel from one country to another. The World Wide Web does not understand territorial boundaries, and you can go anywhere without any questions being asked and so on and so forth. You know this idea. Now, which basically means that because of the advent of technology, opening up of borders and a relatively calm period of, I'm not saying there is no violence, there are no wars. I'm not trying to discount the Russian invasion of Afghanistan or the American invasion in Iraq or what do you say, Korea, the Korean War or the Vietnam War. I'm not trying to discount any of that, but generally post the Second World War, the world has been at peace. After the World War, it's not seen that many people getting involved in armed conflict. There's no armed conflict which has disturbed the economies of all countries around the world, which basically means a relative sphere of calm has existed over most of the world. There have always been some parts which have been in conflict, which has resulted in economies starting to rely on each other and benefiting from each other's expertise. Which brings us to the fact of the idea of opening up of borders and globalization. Now, India started that entire concept and moved away from the Nehruvian model around the Narasimha Rao government, where Manmohan Singh was the finance minister, and we started opening up our borders over there. Now, why that's relevant and why we need to understand it is because at that point of time, India was still at a very nascent stage of development when it came to our pharmaceutical industry, and we required allopathy to become a popular source of remedial remedial rescue available for a large population, which did not have access to advanced allopathic medicines, and therefore the state of health infrastructure in the country wasn't great. But one of the apprehensions that most pharmaceutical companies, primarily based out of the United States of America and some countries in the European Union, was that our laws are not strong enough to protect the inventions that they bring in, and therefore they were afraid of reverse engineering and recreation of their products, and the law not being strong enough in India to protect it. Now, please understand, the Nehruvian model believed in the idea of socialism and being produced by the government, controlled by the government, and so on and so forth. And we started opening up that idea, started privatization, post-privatization, started allowing foreign companies to come into India. Our laws needed to change with that. This brings us to what is referred to as the trade-related aspects of intellectual property rights, or in short, what is referred to as the TRIPS agreement, TRIPS, trade-related aspects of intellectual property rights. What is the TRIPS agreement? Let me explain to you in a nutshell. The TRIPS agreement basically lays down a minimum standard that needs to be achieved by all signatory countries with respect to all their intellectual property laws for allowing cross-border protection. So what they did was they laid out what minimum standards need to be achieved in copyright law, in trademark law, in patent law, and what are the requirements that need to be fulfilled. Every law must meet that minimum standard. If you become a signatory to TRIPS, you must achieve that minimum standard. You can exceed that standard, but that minimum standard has to be met. Now, to just give you an example, under patent law, what we had in place prior to the signing of the TRIPS was what is referred to as a process patent. We did not have what is referred to as a product patent. What is the difference between the two? What India protected was the process of manufacture of the product, not the final product in itself, which basically meant that if you've got a product, if the pharmaceutical industry in the US introduced a product in India, and we reverse engineered the process of manufacture of that product, and we found a different way to manufacture that same product, the pharmaceutical industry would not be able to do anything about it because the final product in itself was not protected. Only the process of that manufacture was protected. So what happened was, over a period of 10 years, we signed it around 1995, and we had 10 years to comply with TRIPS, and by 2005, we'd become TRIPS compliant. Our laws changed and we accommodated all of these changes. So TRIPS is something that we will be talking about, or the effects of TRIPS we will have to deal with. It lays down minimum standards that need to be achieved in terms of term of copyright, with respect to the term of patent, what kind of patents can be allowed, what kind of copyright can be allowed. The very fact that copyright inherently exists in anything that is created is a result of that TRIPS agreement. Otherwise, all copyright earlier needed to be applied for. Okay, now, so this is the TRIPS agreement. The next thing that I want to talk about now is coming back to the fundamentals of copyright. All right. Now, with respect to the fundamentals of copyright, I'll just reiterate what we've spoken about yesterday and then move on. Copyright is basically a set of rules and regulations that have been created to protect cinematographic films, sound recordings, literary works, artistic works, photographs, softwares, and things in that genre. So artistic expressions are protected. I've given you that example of the difference between the idea and the expression. Love can be a concept or an idea. The expression can be varied. Just to give you an example, all of you will remember the the song. So the idea of copyright basically is jiski lati usi ki bhais, which basically means, okay, I'm sorry, actually I shouldn't have said that. Explain that would be a little difficult. Basically, whoever establishes and exercises and enforces their right on something first generally becomes the owner of the copyright, and that's a flaw in the copyright mechanism that exists. So let me give you an example. I think around 2010, if I'm not wrong, 10, 11. The song, there's a movie called Dabang that was released. I don't know if all of you have seen it. You must have been very young. It's not a critically acclaimed movie or anything like that. It's slapstick Salman Khan humor. But the movie had a very, very popular song called Munni Badnaam Hui. I think the words of the song are Munni Badnaam Hui, Jaane Man Tere Liye, or something like that. Basically, it's a slightly erotic number with sexualized lyrics in it. So it's again an expression of sexual freedom. T-Series got a copyright on that, right? But in my surfing of the internet, I came across a Govinda number. Then I came across a Javed Jafri number made by Bappi Lahiri. All of them sounded the same as Munni Badnaam Hui. The Govinda number had come out in, I think, I can't remember when exactly it came out. Let me see if I can, without the video, just make you listen to the audio. If I play the audio, can you hear it? I'm just going to play the audio. Let me know if you can hear it. 1 second. I'm just playing the audio. Are you able to hear it? Yes, no?
No, sir.
No, you can't hear it.
No, sir.
So I don't know how should I play this? Oh, wait. I know exactly how to play it. Just give me 1 second. It's very important to hear this. The name of the song, however, is not Munni Badnaam Hui. It's Govinda singing to a girl, so it's Chhora Badnaam Hua. I need you to hear this to understand how complex copyright is. All right. You're able to hear this now?
Yes, sir.
Yes, sir.
I'll just forward it to the relevant part. Now, you would not believe it, but there are 29 versions of this song. Not 1 or 2, but 29 versions that I know of. There are 6 Pakistani versions of it. Salim Badnaam Hua, Tina Tere Liye, Londa Badnaam Hua, Hasina Tere Liye. Then I tracked it back. The original version of this song, or the so-called first version of this song, was created by this artist in 1972 called Razia Begum. She came out with Londa Badnaam Hua, Londia Tere Liye. It was a Thumri song, again a sexualized version of what existed as expression of sexual freedom back then. But all of that was a precursor to this song that came out. But copyright मिला है इसको क्योंकि इनमें से किसी ने भी इसके पहले copyright के लिए apply भी नहीं किया था. Now, what this basically does is, because theoretically T-Series owns the copyright on the song Londa Badnaam Hua, Munni Badnaam Hui, everything else that has come prior to it automatically has become illegal. Now, theoretically, if you look at it logically, आप logic को apply करेंगे तो आपको ये लगेगा पहले वो आया है, और क्योंकि वो पहले आया है तो बाद में जो आया है उसको कॉपीराइट नहीं मिलना चाहिए. लेकिन कॉपीराइट के अंदर, अनलाइक पेटेंट, दिस सिस्टम ऑफ search and searching and finding out. I told you about the idea of novelty and global searches for novelty. That does not exist under copyright law. We can go and file a complaint, or the creators of the earlier forms of music can go and file a complaint कि भाई ये copyright नहीं दिया जाना चाहिए क्योंकि ये एक नकल है already existing गाने की. That is something that can be done, but it hasn't been done as of yet. The point is that is not a reality of what has been done as of yet. Therefore, it is very, very easy to violate copyright in a manner in which the rights of the owner of the creation gets subdued. Now, let me give you another example. If you remember, I had told you about Raja Ko Rani Se Pyar Ho Gaya, that song, Amir Khan and Manisha Koirala song. Now, you'd be surprised to know that the original version of that song is actually from a movie called The Godfather. There was a book written by this author called Mario Puzo. The theme song of the song, The Godfather, is exactly the tune which has been used in Raja Ko Rani Se Pyar Ho Gaya. Again, a blatant copyright infringement, but nothing's been done about it. So it also has to do, please remember, this also has to do with the enforcement of copyright. If you can understand, the enforcement of copyright is a very different question from whether a content is violating anybody else's rights or not. Again, to give you an example, there's a very, very funny movie which I personally like, which has Will Smith in it, and I don't remember, Eva Mendes, I think, called Hitch. It's basically the story of a guy who's helping another slightly awkward gentleman trying to figure out how to approach and talk to women and become friendly with them and then start dating one of them, hopefully. Basically, he's an awkward person and does not know how to have conversations with women. So the plot line is that, and Will Smith plays a stellar role in it. Now, there's an Indian version of it which is absolutely horrendous. It's something that you should not watch even if you're close to your brain rotting, you should not watch, because it's so horrible and badly made that you'll actually fry your brain. It's a movie which has Salman Khan and Govinda in it, called Partner. Right? They've just picked up the entire story and they've pasted it over here with no permission. Now, no acknowledgement, no permission, nothing done. This is one extreme of the Bollywood industry. The other extreme of the Bollywood industry is when the movie Three Idiots was released. There was a suit and a claim made by Chetan Bhagat that there are parts of this movie which are inspired by some of the novels that he has written. There was an out-of-court settlement and all of that got sorted out. But that is an extreme form of the application of copyright. So basically, copyright also has to do with the implementation or the enforcement of rules and regulations that come with copyright. But what you need to remember about the idea of copyright is, once a copyright exists in a work of art, and I'm not saying, please remember, I'm not using the words granted, because copyright need not be granted. As soon as an author, a creator, a photographer decides by her or his standard that the work that she or he has created is complete, it automatically has a copyright. It need not be applied for. It is recommended to protect your rights under the existing law, but it is not required. Now, as soon as she or he decides that the work is complete, it automatically has a copyright. Now, what does having a copyright on the work mean? This means that all rights reserved, that's the tagline of copyright. If you see copyright with a C, below that there'll always be written all rights reserved. The question that we need to ask is, what do we mean by all rights reserved? What are these all rights which are reserved? The rights which are reserved are, nobody can do anything with respect to that content without your permission. Now, what do you mean by can do anything with respect to that content? What you mean is you cannot adapt, translate, modify, sell, distribute anything without the permission of the owner of such content. So, for example, if you see some content online which you really like and you want to use it for your TikTok video, copyright theoretically does not allow you to do it because all rights are reserved for the in favor of the person who is owning that content. Without their permission, you cannot do it. So basically, theoretically, everything that you see during the Ganpati festivals, where the pandals are put up, and in the morning we've got all kinds of aartis and all that happening. Even the aartis, for example, the aartis would have been sung by some artists, not anybody at the pandal itself. And there will be production houses which will be a part of the making of that that aarti, that song. Like, for example, there is one very famous one which I generally listen to very often. It's the Amitabh Bachchan's version or rendition of Sukharta Dukharta. So, and I've seen it playing in a lot of, because he's got such an incredible voice, I've seen it playing in a lot of pandals. That's a copyright violation because you've not taken permission from the owners of that production. I don't know who's created. I think it's T-Series, but I'm not very sure. I wouldn't put my money on it. But we've not taken permission from them. हमने तो बजा दिया है यहाँ पे. कोई permission नहीं लिया है. You cannot sell, reproduce, show, distribute anything that with respect to that content without permission. Similarly, anything that happens in most pubs and discotheques is a violation of the copyright. Why? Because none of these individuals will be using streaming services like Spotify, for which they've paid subscription to play the music, because then the quality of the sound is not generally good and buffering becomes an issue. So most of these people hire DJs who would have downloaded the content onto their console and then they play it from there, because the era of CDs is gone. So nobody burns music anymore onto the MP3 format. So CDs are out of the picture. But what they do is they download that content into their system. If they have downloaded it from an app, which is like a Gaana or a Wink or a Spotify or a YouTube Music Premium, whichever the music app is, and that app allows them to download it and they played it from that, then it's okay. Otherwise, most of these cases, they're copyright violations, because what any of these apps allow you to do is play it for a private purpose. If I download it and play it on my phone, no problem. But if you look at the contract that you have signed while signing up for Spotify or while signing up for YouTube, it will say you cannot use it for a public performance. What is a DJ doing? He's calling people into a particular area and he's playing music for them. It's a public performance of somebody else's music. And then without their permission, he remixes that content also. She or he remixes that content also. Now, this controversy initially began with the remix era with this DJ called DJ Akil, if I'm not wrong. And one of the famous songs that caused a lot of controversy was this very old Bollywood number called Kaanta Laga. Now, all DJ Akil did was, at that point of time, the entire idea of remixing of music was also very, very basic. Now, remixing of music itself is an art. The remixing of music was very, very basic over there. All that he did in that music was reduce the treble, made the sound a little bassier, and introduce a bass rhythm into the background of that music. So it's Kaanta Laga, and then all that he did was in the background put in percussion, and then just on that beat, on that 2x2 beat, he just had that song playing along. And that was the first versions of remix that caused controversies in India. But again, the question came up, bhai, ye to aapne kiya nahi hai, ye aapka kaam nahi hai, ये कैसे allowed है? And this brings us to the question of copyrighted works are created for protecting the expression of the artist for original expressions. Please remember, the word that I'm using is original. All right. In patent, we use the word novel or new. Over here, we are using the word a copyrighted work must be original. Now, I'm just throwing the floor open to everyone. Can somebody try and explain in their version, what do you think the word original means? What do you think we are trying to say when we are saying the work has to be original? Can anybody try and explain? Anybody wants to take a stab at it? Don't worry, even if you're wrong, that's perfectly all right. Yeah, go ahead.
So it can be something originated from one's own intellect, like not copied, not actually copied, but not like I hear something and then I decide to make music in that way. Then just not remixing it or.
Good, very good try. I know this is a complicated idea and therefore it's a little difficult, but please, but very good try. Does anybody else want to give it a shot?
Sir, is
Yes,
this
sir.
a piece of art that hasn't been registered before? As
No,
copyright?
registration has nothing to do with originality, because unregistered content can be original.
Sir, I feel that it should be coming very much from the originator, like the actual person who created it.
Okay, could you explain that, please?
It means like if I have produced, like if I have actually composed a song, then it actually has to come from my side only. No other creation has to be done in the way I have done it.
So let me ask you this question, Aditi, because you're very close to the right answer. So let me just try and ask you some questions about it. And please, anybody can feel free to answer this. So let me play that so that you can understand what I'm talking about. Please bear with me. This is. Okay, just bear with me for 2 minutes and listen to this. Not this part. Okay. This part now. Just listen to this part. All right. This has come in later. Now I'll make you listen to the original. Just wait. You'll realize what the similarity is. Can you hear the similarity between the two?
Yes, sir. Like
Yes,
the
sir.
tune is exactly the same.
Exactly. मतलब अनु मलिक ने कोई दिमाग नहीं लगाया. लिरिसिस्ट ने लिरिक्स जरूर लिखे, लेकिन म्यूजिक क्रिएट करने में कोई दिमाग नहीं लगाया. अब the question is, ये ओरिजिनल है क्या?
So maybe yesterday we were talking about
Sir,
being
it
inspired
can
by
also be
somebody else.
sampled, right? There many times in music.
Just one by one, please. I think somebody was trying to speak.
Yeah.
Kalpita, just 1 second. I'll give you a.
Can you moderate? Asta, can you
Yes,
moderate this? Yeah.
311, wait, please go ahead.
Yeah, so I was just saying sometimes on music, it's like people can sample each other's music. Not
Correct.
all of it, but like maybe a tune or maybe a couple of seconds, just base the song off of that.
So you're absolutely right. But there was a very famous case in which you remember George Harrison. He was sued for some $1 million for unconsciously copying 2 seconds of a song. Unconscious. There was not even a conscious copy. Some millions of dollars he was sued. So sampling is great. Yes, sampling. But is sampling allowed? Is sampling therefore permitted? That becomes a question. Do you understand? Your point is very well taken, but then we'll try and address this issue also. So anybody else wants to take a stab at it? Do you think this is original?
Sir.
So actually, sir, I have this question since yesterday, and since you brought it up today, I think when it comes to music specifically, we can use copyright in terms of maybe lyrics, but when it comes to music, it becomes very subjective. So, for example, if you remember, a few years back, a very popular indie musician, Ritviz, slammed a very popular music label saying that they copied his entire song Ud Gaye, which is a very famous song out there.
Ud Gaye, yeah.
And when he actually put this out on social media, he received a lot of support from the people in the music industry. But
Correct.
He eventually did not, because I followed the whole thing. He eventually did not do anything about it because what he got from people like the experts in the law field and everything is that music is very subjective. So even if he sues them, there's not going to be there anything out of this. Even if you see, there are so many songs that I myself find very, very similar. But what the in terms of legal listing, what they say is that basically music is very subjective. So what you might feel is similar, others might not find it very similar. So
I can understand that, Gautami. Thank you for sharing that opinion. But in some instances, the copying is blatant. Right? There's the application of the intellect to create something which is inspired of somebody else's creation is not there. Like, for example, let me give you another example. A.R. Rahman's creation, which is Dil To Bachcha Hai. I'm sure all of you may have heard of that song, Dil To Bachcha Hai.
Yes.
It is a copy of a song which was created in 1928 called Bolero. It's an inspiration from there. The problem that copyright faces is it's difficult, just like you have said, to decide where inspiration ends and where copying begins. But traditionally, we've always been an organization, or sorry, a system, which in India especially, whether you look at Kishori Tai's, Kishori Amonkar is a very, very, very famous singer. You guys will not know about, may not know about her. One of the most famous singers that I have come across from the yesteryears. Her work is appropriated by everyone, because at the time when she used to perform, you just needed to go with a tape recorder, sit next to Kishori Tai and ask her, may I record your music? And she used to say, please do whatever you want to. And people have recorded versions of people like Ustad Bismillah Khan, Kishori Tai, all of these very, very renowned, famous performers. But the idea that you cannot recreate like this at that point of time did not exist. Now that it has been created, the digital era is asking questions left, right, and center. Because if you look at TikTok, TikTok is nothing but appropriation. Now, whether that appropriation is right, it is wrong, whether it is with permission, whether it is not with permission, whether the person who is created the music wants that music to be appropriated in such a manner or not is the entire argument. Now, I might create a music and people might start doing some dance to it. Right? I yesterday or day before I saw David Warner, the cricketer, the Australian left-handed batsman, opening batsman, do a dance step from a new movie, Tamil movie that has come out. Again, he used the music. He created some kind of a video. It was a very funny kind of walk. I don't know. I saw the original version also, and then I was very surprised that he did something like that. But it was in fun. And this brings us to the slightly complicated part of copyright. Please remember that there are certain, I've already told you that copyright, you cannot do anything without the permission of the owner because all rights are reserved. Okay. But there are certain exceptions to the idea of copyright, and that's where some of these things tend to fall under and therefore cause confusion. Exceptions to copyright. In which situations will copyright not result in violation of the law? What are these situations? For example, giving a criticism on some work. So, for example, if I write a book, okay, you are a reporter or a critic of books and magazines and all of that, and you take certain excerpts of my book to write a criticism about it. Okay, a critical analysis which for which you need to take excerpts out to build your argument of whether that book is good or bad. Now here it's not a violation of copyright. If you comment on something, so whether it is good or bad, it doesn't matter. So if I'm commenting on Shobha Day writes an article, I want to write a comment on Twitter about Shobha Day's article. So I pick up content from that and I write it. Again, not a violation. News is not a violation of copyright. So for example, if there is an event that takes place like, for example, a cricket match. So India, South Africa ODI series, 3-0 whitewash, and I have excerpts from the broadcast that took place. Now, the broadcaster will have their own rights to broadcast it, and you can't use that content. So if you see YouTube, as soon as the match gets over, gets certain clips of the wickets that have fallen or the sixes that have been hit, the fours that have been hit. But these videos very quickly get taken down. Within about 24 to 48 hours, these videos get taken down because they are without the permission of the broadcaster. Channels like Crick Info, ESPN Cricket, all of them have rights to take out excerpts and then do it because they've got a collaboration with the broadcasters of those shows. Now, what was I trying to say over here? Yes, so news. So when the news picks up this information from a broadcaster saying that there was a whitewash and they show Mohammad Shami picking up a wicket or what do you say, Quinton de Kock hitting a six or something like that, that's a part of relay of news. For the purpose of relaying of news, taking these excerpts is permissible. Similarly, for news reporting, it is permissible. For what do you say, research, it is permissible. So when you guys take contents out from the internet, whether it may be from Wikipedia or a white paper that has been published online or a piece of music to embed into your PowerPoint presentation, all of that is permissible because it is for research purpose. And obviously for teaching purpose also. So teachers are allowed to do it for the purpose of teaching. Now here, I'd just like to point out a very major controversy that took place with, yeah, sorry. Did somebody say something? No. Okay. So a very major, yeah, yes. Does somebody want to say something?
Is anybody's mic unmuted?
No, ma'am, I don't think so.
Okay. Sorry. Not a problem. A very major controversy took place in Delhi, under Delhi University. It's called the Delhi University photocopying case. There's a, now all of you have been to the Symbiosis campus. अब जो कैंटीन के बगल में वो जो फोटोकॉपिंग शॉप है, वैसी एक फोटोकॉपिंग शॉप थी दिल्ली यूनिवर्सिटी में, जहाँ पे कोर्स पैक्स बनते हैं. जैसे हमारे यहाँ पे फर्स्ट ईयर बीकॉम, सेकंड ईयर बीकॉम के कोर्स पैक्स बनते हैं. आप जाके बोलते हो फर्स्ट ईयर बीकॉम का एक्सर्प्ट्स निकाल के दे दो. एग्जैक्टली द सेम थिंग हैपेंड इन दिल्ली यूनिवर्सिटी. नाउ व्हाट हैपेंड इन दैट केस वाज the professors go and say that this is the book. For example, if you're marketing के लिए आप या एडवर्टाइजिंग के लिए आप फिलिप कोटलर पढ़ रहे हो, पूरी फिलिप कोटलर तो खरीद नहीं सकते. इट्स एन एक्सपेंसिव बुक, यू कांट buy it. So what is generally done is your professors make the effort of taking out certain excerpts which they believe are very important from the book, go and give that excerpt to the they borrow the book from the library because the book is available, They go and give it to the photocopy person and they say, please photocopy pages this one from this one. And they make a compilation of these pages and they give it to the photocopy person. The photocopy person follows the instructions of the professor, copies all of this content and makes a course pack for each course. So economics ke liye ek hoga, what do you say, accountancy ke liye ek hoga, so on and so forth. वो course pack बना के रखता है. तो and you as students go and say BCom first year की या BA English first year की course pack दे दीजिए, and then they give it to you at a particular price. So what does that price include? The cost of photocopying, the cost of spiral binding, and whatever the plastic that they put on top of it, and they charge a little bit of a profit and they give it to you. Now, publishers, there are certain publishing houses like Oxford, Walter Kluwer's, Cambridge, and another one. I don't remember the fourth one. They went and sued this. Rameshwari Photocopier was the name, and Delhi University, saying that they are violating copyright. Copyright in those books exists. They're expensive books, and they said that you cannot photocopy. And what was their argument? That even for research purpose or for teaching purpose, what is permissible internationally is 10% of the content can be copied. But there were certain books in which there was 30% of the book which was photocopied. So compilation of that, and let us say 10% in total. But that course compilation, 100% is photocopied. There's nothing original in it. It's just a compilation of photocopied content of all our publishers' works. So this is a loss of revenue for us, and this is wrong because internationally only 10% is allowed to be photocopied. Just a bit of tidbit of information for you. The meaning of the word photocopy legally is called reprography. 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 To reproduce. To graphically reproduce is called reprography, which is now commonly known as photocopying. This case went before Delhi High Court, and I'm extremely proud to say that the judge who passed the decision in this case is a judge I worked under when he was an advocate, and fabulous gentleman. But what is extremely hilarious is his name, and I've always told sir that how have you managed to live so many years in Delhi with that name? His name is, believe it or not, now he's retired from the High Court. His name is Rajiv Sahai. That's not the funny part, but his title is End Law, ENDLAW. Now imagine you've got a justice or a sitting High Court judge and says, and then when you introduce the gentleman, you say, I would like to introduce Justice End Law. Who is going to give you justice? He's the end of law. He's got the most funny name. In any case, the decision that he passed was exceptional. It went against international standards, international conventions, and he cleared the air of copyright. He said, India is a socialist country. India is a country in which higher education is subsidized through universities. The amount that we charge for our students to study in our colleges is not something that is left to the private entrepreneurs and organizations to freely decide. It is regulated under not the private university system, but under the university system. So for example, if you look at the fee that you pay at the Arts and Commerce College, it will be different from the fee that is paid in other symbiosis colleges, because Arts and Commerce falls under Pune University. So the fee is regulated over there. There is a control on the fee. And the university systems tries to make education affordable to students by themselves funding colleges. So the universities give funding. जैसे आपको अभी ये lecture organize करने के लिए funding मिली है, ऐसे बहुत types की fundings universities को दी जाती है, which is generally not given to private universities because they are self-funded. So I don't want to go into a discussion on self-funded and university-funded institutions, but the idea is the average student in India cannot afford to buy a Philip Kotler, cannot afford to buy an expensive book, which Oxford or Walter Kluwer said. So the judge very categorically in this case said, it does not matter how much you photocopy as a student. आप पूरा का पूरा photocopy कर लो, 10% छोड़ो, भाड़ में गया, 50% छोड़ो, आप 100% photocopy करो, as long as you are photocopying for your own personal use. You can photocopy as much as you want. The restriction that has been placed is on colleges and their libraries. You cannot have photocopies of original books kept in the library. आप लाइब्रेरी में फोटोकॉपी करा के नहीं रख सकते बिकॉज उसमें फंडिंग मिलती है आपको, तो आपको ओरिजिनल कॉपीज रखनी पड़ेगी. एक मेरे ख्याल से द रेस्ट्रिक्शन और द लिमिटेशन इज दैट यू कैन कीप वन कॉपी ऑफ इट बट नॉट मोर देन दैट. So over here also there was an exception which was created for students, and that exception was clarified under what circumstances it will be non-violative. So please understand, copyright has restrictions. It does not permit anything to be done without the permission of the owner or the person who's created the content. Apart from these exceptions like teaching and research and fair commenting and critiquing and news reporting, all of these are exceptions. Because please remember, the purpose of all of this is not profiteering. They are not, none of these situations are situations in which they are trying to profit from the creation of another individual. They are merely trying to use that creation either for private use or for the purpose of spreading information. So that's why there are exceptions created to copyright. Softwares also have such restrictions. अगर आप एक सॉफ्टवेयर उठा के अपने कंप्यूटर पे डालते हो, लाइक फॉर एग्जांपल आपने एंटीवायरस खरीदा, एक एंटीवायरस आपको बता देगा इवन इफ यू टेक अ फैमिली पैक हाउ मेनी डिवाइसेस यू कैन पुट दैट कंटेंट ऑन, एंड after registering the number of devices, you will not be able to add devices on, and if you do, it's illegal. This is what is referred to as a EULA, or an end users license agreement, which basically means copyright is a set of rules and regulations for regulating the conduct between people with respect to content created. This conduct is actually regulated through contract law, because whether you are signing an agreement with Instagram as to what kind of picture. So for example, if I want to tomorrow upload a nude picture of myself, Instagram will say no because it's against a policy that they have. So Instagram will delete my account. Why? Because I've signed an agreement with them. Similarly, if I tomorrow want to put up content of, for example, who do I say? I want to put up Ritviz, since somebody brought up Gautami brought up Ritviz. I want to put up a Ritviz song and a part of Ud Gaye video on my handle for whatever reason, and I'm not acknowledging this person. As per the contract that I've signed with Instagram, Instagram can turn around and say this is a violation of our rules and regulations and policy. Or if Ritviz finds that song and he says that this is a violation, I want this to be taken down, they can report this content to Instagram and Instagram can take down. This is what is referred to the notice and take down policy. So a lot of content can be regulated through this notice and takedown policy, which is a copy of an American rule called the Digital Millennium Copyright Act. We've got such rules and regulations over here, but I don't want to complicate that idea too much. So copyright is a set of rules and regulations on what can and cannot be done with respect to artistic, cinematographic, literary works. But that is actually controlled through a concept of contracts between individuals, wherein if you do something against it, it's a violation of the contract, and then copyright steps in to protect that violation. Am I making sense till now?
Yes, sir.
Yeah, okay. So I'll throw it open for questions. Elena, I know you've been raising your hand for some time. I'm sorry. Please go ahead and ask. Whoever has questions, we'll take about 10 minutes of questions, and then I'll move into the next part.
Elena, please go ahead.
Yes, sir. So you said that the copyright, you cannot, the rights are only with the person who has originally created the work, right?
Correct. Under copyright.
So, yeah, so this includes even the work that is not exactly registered, right?
Yes, unregistered works also.
Okay, so I am someone who makes music, and
Okay.
I have one of my songs out on YouTube.
Okay.
So if someone else sung my song, as long as they specified that it's originally by me, or they said that it's a cover, I would be okay with it. But if someone tried to blatantly say it's their original song, I can stammer it.
Yes, you can. It will be a violation of copyright. But what I will teach you, hopefully by the end of this class, Elena, is to get your own copyright on it and officially get your copyright on it. All right. So copyright inherently exists, I told you. But how do you enforce that right? And how do you claim that you were the first person who's created it? What we'll try and do is try and figure out how to get and enforce this right and where you can go and do it on your own without hiring a lawyer, without going to a copyright office. There are ways and means of doing it through the copyright office. The government has established institutions where you can approach and register your copyright. But how can you do it sitting at home without any external help? That's what I'll try and explain to you. Yeah.
Okay, sir. Thank you.
Thank you, Elena. Next we have Soumya. Please go ahead. Soumya. Okay, Malik, you can go ahead.
Good afternoon, sir.
Hi, good afternoon.
So we talked about the originality. So if we see that in recent times, there are many Bollywood movies about the biography of a person.
Correct.
How much the knowledge I have that the director requires a permission from that person whom they are showing. So there are the instances like there have been movies in which the biography of a person was shown who was dead. So can there be any claim from his legal hire or his legal family?
Absolutely, Malik, you're absolutely right. If there is a movie that is made on an individual and the depiction of that, and people object to the depiction of that individual in that movie, the legal heirs can object to it and then they can file a case. Yes, absolutely. Because that falls into defamation, or that falls into the category of, so you'll have to turn around and say कि आपको objection किस type की है उस चीज से, कुछ गलत दिखाया है. Because अगर for example, agar, go ahead.
I'm saying that the life is something which is which is very private to someone.
Right.
Even though the person is criminal, like there was a movie that showing the rise and fall of Harshad Mehta.
Correct.
Who was dead back in 2000.
Correct.
So they have showed all his private life. So I was thinking that why cannot his family show? Even they have shown all the conversation with his family, brother, or what else he was doing. And there was another.
You're absolutely right. And if that has been done without the permission of the relevant people, they have the right to take objection to it. Absolutely.
So, but the relevant person is dead.
No. So the legal heirs are still relevant people, na?
Oh, okay.
The legal heirs are still relevant people. Like for example, let me try and explain this to you with an extreme example. If tomorrow somebody tries to use Shakespeare's name for creating porn, the Shakespearean Society can take objection to it. Okay, Shakespeare is long dead and gone. लेकिन अगर उनके नाम पे कोई pornographic content बनाने की कोशिश करता है, तो उसके ऊपर objection लिया जरूर जा सकता है. शेक्सपियर को तो कोई मतलब दफनाए हुए पता नहीं कितने साल हो गए. So the Shakespeare Society, the society that takes care of him and his work and his reputation and his name, can take objection to that content. Absolutely. It does not matter whether the person herself or himself is dead or alive. Yeah, does that answer your question, man?
Yes. Thank you, sir.
Okay. Go ahead. Next question.
Next we have Akshat. Akshat, please go ahead.
Good afternoon, sir.
Good
it has been an amazing session till now. I've been following it since yesterday. So the question I had a question for yesterday as well. So if you don't mind, could I go ahead with that?
Please go ahead.
Sir, so as you know, many companies like Tesla, they open source their codes. Correct. So how do they protect it so that others don't patent it and claim it as their own?
Brilliant question, Akshat. It's slightly complicated, but it's a very, very relevant question. I'm just surprised that all of you've got. I mean, I generally teach this in my courses over a period of time, but I'll try and answer it very quickly. Akshat, open source has to be distinguished from proprietary content. So let me try and distinguish open source and proprietary content for you. The basic difference between open source and proprietary content is like the difference between a Firefox code and a Google Chrome code. Both are browsers, but the code for one of them is available in the open market where people can adapt, translate, change, modify, and do whatever they want to with it. On the other hand, the Google Chrome code is available only in an executable file. But let me explain with a simpler example. The difference between open source and proprietary is the difference between Nimbu Pani and Thumbs Up. Nimbu Pani is open source, Thumbs Up is proprietary. नींबू पानी आप घर पे भी बना सकते हो, उसके इंग्रेडिएंट्स आपको पता है. अगर आप चाहो तो आप दुकान में जाके नींबूज या फिर LMN या फिर लिम्का, all of them are version of नींबू पानी, whether it's aerated, whether it is mixed with masala, nimbu masala, whatever, or you can make it at home. Whatever the versions are, you can do it because the process of creation is available to the general public to modify, change, adapt, do whatever they want to with it. Thumbs Up, on the other hand, is proprietary content because it is available only in a finished product form, executable form. आप पी सकते हो उसको, recreate नहीं कर सकते क्योंकि उसको formula आपको देंगे नहीं वो. So that's the difference between proprietary and open source. Now, to protect proprietary content, they have various laws like copyright and patent and all of that. To protect open source content or content which is not under copyright, we've got a different set of laws, but remember this difference between open source and proprietary, which I've told you, and I'll jump into that question as soon as we finish the question answer session. And I'll come back to you and ask you whether it's clarified or not. That's a very relevant question. Thank you for asking that.
I had a few more questions.
Yeah, go ahead.
So as you said, like you can use someone's content for fair use, as in like giving review or something. So a lot of like companies, even like Byju's, they have sued such creators for reviewing them or like even using their name in their video or their logo.
Correct.
So how's that like? How can they?
See, देखो, अक्षत, sue करना problem नहीं है. लेकिन whether that is sustainable in a court of law is a very different question. So what a lot of these very large companies which have got a lot of money do is by way of deterrent action, they say इसको भी sue कर दो, उसको भी sue कर दो, ये भी गलत है, वो भी गलत है, सब कुछ गलत है. मतलब that's what Facebook does, that's what Google does, that's what all of these large multinational corporations which have got tons and pots of money do. They file cases left, right and center. अब violation किस चीज के लिए बोल रहे हो आप? किस चीज का violation बोल रहे हो? अगर मैंने वहां पे if Byju's is able to prove that the purpose of using their logo or their trademark was to confuse the customer into believing that the person making the video belongs to Byju's, then they will lose the case. But just using the word, the logo of Byju's, because otherwise how will people get to know that they were talking about Byju's? So they put the logo up in the corner. They might at best turn around and say कि ठीक है आप वीडियो में से वीडियो what do you say logo निकाल दो और फिर रिलीज कर दो, कोई प्रॉब्लम नहीं है. But to successfully file a case where there will be monetary compensation or imprisonment or something like that, literally impossible. So enforcement of rights के लिए all of these big organizations which have lots of funding keep enforcing their rights to see how much of monopoly they can create with respect to their name. To give you an example, Facebook is like the epitome of this. Facebook actually at one point of time exercised monopoly to such an extent that if you look at Facebook, the name, it's a combination of face and book. Now, what they were able to do was they created a monopolistic system in the trademark regime wherein no individual was allowed to use the suffix book with respect to a social media entity or anything similar to Facebook. आप book use नहीं कर सकते थे. For example, there was an organization which was called Place Book. They sued them, won. There was another organization called Teach Book. Teach Book was basically a collaboration of teachers where they came and shared their resources, their teaching experience, their content, all of that refused. There was a sex site called Fuck Book, also a social media entity which was trying to bring like-minded sexual partners together. So it was a a sex-based dating app kind of thing. Sued, won. All of these, the extent to which Facebook was able to exercise its monopoly over the suffix book was astounding. Now, that kind of nonsense happens in India also. For example, the Tata organization was able to win a case against OKTataByeBye.com. Correct? Tata Group, as in Tata, the Tatas, were able to win a case against OKTataByeBye.com. Obviously, over here, you are using the word Tata as Tata, not the Tata, but they were able to win it. So it depends upon the organization. It depends upon the individuals who are deciding the case. Logically, in my head, it makes no sense, but I mean, I've seen strange things happening. But according to me, having said that, a fair comment on Beju's or using of their logo for the purpose of creating a video commenting on their products, I don't think is wrong, because you're not trying to misuse. Please understand, the purpose of a trademark is to help distinguish between products of a similar nature. You are not using the trademark of Beju's to appropriate their customers. That would be wrong. Akshay, does that answer your question?
Yes, sir, it does.
Okay.
So like just to like add on my that open source question, I also like to add, like in YouTube, many creators just like opens like kind of like quote unquote open source their songs, but there are some uploaders who copyright that original uploader's song, and then they copy strike other creators using that song, even though the original creator has said that you can use freely.
Correct. Absolutely right. And that is illegal. That is not right. And we will deal with the solution of that problem also. When I will answer Elena's question on how to copyright on your own, we will be addressing the answer to that question also.
All right, so thank you so much.
Okay. Thank you. Thank you, Akshay. Siddharth?
We take a few more
sorry,
questions.
Asta, please handle this.
Hi, sir, can we take a few more questions?
Yeah, please.
All right, Siddharth, go ahead, please.
Yes, good afternoon, sir.
Good afternoon.
Sir, first of all, it's a wonderful session and we enjoyed and learned a lot. Thank you for it. And
thank you.
Sir, my question is regarding that just a few minutes ago, we discussed about what was from where does the copying starts, or from where does it violates the copyright issues. So I want to ask that nowadays we all know that in Instagram or other social media platforms, the memes materials or the digital content for entertainment are very popular. So, sir, in these memes, the creators use an extract or some part of existing movie or anything other social issue, and also they have their own originality as they use their own mind in these things. So, is it a violation to the copyright, or it is not?
See, the copyright is also a very dynamic kind of law, and it is going through transformation because of the technological advancements which are taking place. Now, if you see one of the songs, it's an item number which has become very popular. It's a Tamil song, ooh, something, ooh, Vannamma, something. I don't know Tamil that well. And everybody is dancing to that song. Everybody is picking up that song. They're making videos on it. I mean, YouTube in shots are just flooded with people dancing to that song. So what are you doing? You're picking up the song, you're seeing the steps performed by the artists in the movie, and you're trying to recreate that in your own way and then upload it onto YouTube for other people to see. TikTok's full of that. All of, for example, memes that are created. What are memes doing? For example, one of the most popular memes that became was during the Donald Trump campaign, there was a photograph of Bernie Sanders that became extremely popular, and you appropriated it into a group of friends sitting, and then in between there is Bernie Sanders, and then you've got some content written on top of it. Or the mistakes that Rahul Gandhi has made during his speeches. You pick them up and then you put it into a different context, and then you make a meme or a joke about it. Over here, please understand what you're doing is memes are generally in what is referred to as the genre of parody. Over here, you're not trying to generate revenue out of it. You're just putting it up for people to view and see and appreciate and critique. Over here also, in all probability, this will not be copyright violations. more so because of the nature of the violation that is theoretically taking place and the purpose with which it has been created. If the purpose of this content was to generate revenue based on the use of that content, then yes, they would. It would be a copyright violation and people would be sued and people would have to end up paying up money. But as long as it does not result in that, I don't think it would be a copyright violation, even if there is appropriation of content without permission.
Yes, sir. So one more query related to this only. Sir, for example, like you said, you gave the example of Donald Trump. So, sir, in this case, the meme is published also, and it is indirectly defaming any person. So why don't they file a defamation case?
Defamation suits तो 24 घंटे होते रहते हैं यार. 24 घंटे होते रहते हैं. डिफेमेशन को लेकिन एस्टैब्लिश करना बहुत मुश्किल है. डेफेमेशन का आइडिया क्या है? what is the legal concept of defamation? To reduce the estimation of an individual in the minds of like-minded people in society. So for example, आपने इस लेक्चर के बाद मुड़ के बोला गोकुल नारायण एक नंबर का गधा है, ठीक है, आपने बोल दिया. Now I can take objection to it कि ये मेरे को डिफेम कर रहा है. तो मैं बोलना क्या चाह रहा हूं कि नहीं, मैं गधा नहीं हूं, लेकिन मेरे को कोर्ट में जाके एस्टैब्लिश क्या करना पड़ेगा कि सिद्धार्थ जो बोल रहा है उसके वजह से तृप्ति और गौतमी और मलिक और आस्था और अक्षत और इलेना, आई एम जस्ट रीडिंग आउट द नेम दैट आई कैन सी इन फ्रंट ऑफ मी, शरीयू मैम और अदिति को लगता है कि मैं गधा हूं बिकॉज ही हैज सेड इट. Now, how to establish that in a court of law is one of the most difficult things to do. Theoretically, on paper, academically, defamation exists as a concept, but to establish it in a court of law is one of the most difficult ideas, because what you need to prove is that your words or the words of the person you are suing has influenced like-minded same people in society to change their opinion about you. ये कैसे establish करोगे? बहुत मुश्किल है. But defamation suits तो होते रहते हैं, बहुत होते रहते हैं. देखो, मेरे फ्रेटर्निटी को गालियां बहुत मिलती हैं, but please understand, the process of law in itself requires an unbiased appreciation of facts and circumstances, which takes time, and therefore the processes are slow. I'm not justifying judicial tardiness or the lack of infrastructure or ability available in terms of dispensing of justice, but there are a lot of problems with respect to the inherent nature of unbiased decision-making processes. Yes, please go ahead. Siddharth, did I answer your question?
Yes, sir. Yes, sir. Thank you very much.
Okay.
Okay, next we have Nikhat. Please go ahead.
So I'm just so engrossed in this session since yesterday, and I've been having conversations with my families and friends and everything. So I basically have 3 small questions.
Go ahead.
First is it just is giving credits an exception to like copy somebody, or like if I'm inspired by a song and I'm trying to like remix it, is giving mere credits an exception to it? Or do I have
or permissible? Do you mean permissible?
Not permissible, but like there's a famous artist. I want to remix his music, but I'm just when I'm posting it, I'm just giving credits. Is that a mere exception of example, not getting sued?
Just for the sake of the example, let's presume that you are the famous artist and I'm the person remixing. So your question is, me merely giving you an acknowledgement of the fact that I've taken that music from you, will that protect me from a lawsuit against you, by you? Correct?
Yeah.
See, again, just like I was answering Akshat's question, filing of lawsuits, no protection against it. But legally, what will happen is it will depend upon what rights you have given under copyright. If you have not allowed me to use any part of the content without your permission, then you can't do it. Like, for example, there's a very famous organization, social work NGO called Dasra. Now, there's a Salman Rushdie book called Harun and the Sea of... what was it? I read it a long time back. I forget. Have any of you read it? What is it called? Harun and the Sea of...
Sir Luca and the Fire of Life.
Harun and the Sea of Stories. A novel by... it's a novel by Salman Rushdie. So what Dasra wanted to do was create a an adaptation of that movie for a play. They wrote to Salman Rushdie or his publishers of Harun and the Sea of Stories, and they said that we want to adapt it into a play, and this is what the purpose is. Salman Rushdie's publisher said, no, can't do it. They couldn't make it. They couldn't do it because he owns the rights to that. Even though, they said that they will sue them if they do any work, any adaptation, anything, for any purpose. This was an NGO doing it only for the purpose of using that content to spread a social message, even then. So that's the strange beauty of copyright. Its applications are not decided by the ability to sue or not. They are decided by courts whose opinions keep changing at different points of time. So just to explain this to you further, there was once upon a time a principle called the sweat of brow rule. मतलब आपने मेहनत कितनी, sweat of the brow rule. उसमें क्या बोला था, अगर आपने original, and this will bring us back to that original वाला debate which I need to clarify also. आपने अगर ओरिजिनल काम से अपने काम को किसी तरीके से अलग करने की कोशिश की है मेहनत करके, तो वो कॉपीराइटेबल है. Like whoever had told me that original wala, I think it was Aditi, if I'm not wrong, who'd given an explanation of original, and she was very close to the exact answer of what originality means. Originality only means, so please do not confuse originality and newness. जैसे हम वो वर्ड यूज करते हैं ना कि ये ओरिजिनल है, ये फेक है. ओरिजिनल और फेक का मतलब क्या है? ओरिजिनल और फेक का मतलब ये है दैट जब हम रेबैन जाके फैशन स्ट्रीट से खरीदते हैं, रेबैन एविएटर, उसके ऊपर रॉय बैन, राम बाण, जो भी लिखा होगा in a similar kind of font in the corner of the glass. What is it? It's a violation. But please understand that the violation is a departure from the original work itself. I forgot my chain of thought. I'm so sorry. I've completely forgotten my chain of thought. ये उम्र का तकाजा है. मैं क्या बोलने वाला था, मैं क्यों दे रहा था इसका एग्जाम्पल मैं क्यों दे रहा था? Yeah, I'm so sorry. My mother dropped me a lot of times when I was a kid, so I've got major head trauma. So I tend to forget. I've got the Dory syndrome.
Original and fake.
Original and fake, yeah. But what was the context in which I was going, Akshat? Thanks. Okay, so so let me take a step back. So the idea basically is the Ray-Ban goggle is original because it is created by the company Ray-Ban and can be sourced back to its origin. The other one is fake because although it looks and feels exactly like the original, it cannot be traced back to the original. Therefore, original merely means that it can be traced back to its origin. Now, this is such a loose concept. It's so fluid. मतलब फिर तो सभी कुछ ओरिजिनल है, क्योंकि अगर मैंने क्या कहते हैं किसी और का गाना उठा के उसकी कुछ पलट बना दी, तो वो गाना भी ओरिजिनल हो जाएगा क्योंकि मैंने मेहनत की है. स्वेट ऑफ द ब्राउ, मैंने दिमाग लगाया, कुछ मेहनत की और मैंने उसको चेंज कर दिया. उसके बोल बदल दिए, उसमें थोड़ा परकशन डाल दिया, ओरिजिनल हो गया. क्योंकि इट कैन बी, एंड आई एम सेइंग दैट दिस इज माय वर्क दैट आई हैव क्रिएटेड बेस्ड ऑन दैट पर्सन्स वर्क, जस्ट लाइक निखत वाज टॉकिंग अबाउट. It becomes extremely difficult, and therefore copyright is a matter of enforcement of right more than the acquiring of the right. You can acquire that right, but how well you are able to protect that from other people depends upon how aggressively you enforce those rights. जिसने enforce नहीं किया उनके पास copyright नहीं होगा, और उनके copyright के होने या ना होने का कोई फायदा नहीं होगा. So इसीलिए मैंने वो जो phrase use किया था ना, जिसकी लाठी उसी की भैंस. And this is a copyright reality, that to be able to get a copyright is easy, but to enforce that copyright and protect it, आपको 24 घंटे वो पहरेदार बन के उसके अराउंड खड़े रहना पड़ेगा. कोई नहीं यूज करेगा if that's your purpose. But a lot of people don't enter the copyright regime with that purpose, and that's what the question that Elena was asking. That's the question which Nikat you are asking. It will depend upon you as an individual. Do you want to protect that from by use by me, or is it okay, or are you okay with me using your content as long as I'm acknowledging it? That's a decision that the owner of that content will have to take. Does that answer your question, Nikat?
Yes, sir. Another question was, yesterday I was having a discussion about this with my friend, and she stays in Australia. And then she said that even like projecting a cricket match at a pub or a restaurant is illegal if you haven't taken permission. So I said, no, in India, so usually in the clubhouse when India-Pakistan is happening, that time we're watching for free and there's no permission required because it's just projecting from a phone to a projector to a screen.
Correct.
I mean, how do you need permission for that in India?
You do need permission for that because broadcasting rights fall under copyright law. And so one of the first violations that I was introduced to was when I was a student, and there was the Italy versus France infamous Materazzi incident in which Zinedine Zidane went and headbutted this guy. And I'd seen it in this a theater called E Square. I don't know if you guys know, or it is famous in Pune anymore, but
yes,
I
sir,
watched
it's
it.
still there.
Yeah, it's still there. So I watched it live at E Square. All right, complete violation. E Square had no permission to broadcast that show over there. Then I went and watched the 2000 and कौन सा वाला था इंडिया पाकिस्तान सेमीफाइनल्स किस में हुआ था वर्ल्ड कप का I can't remember the year. I had gone and watched it at there was this hotel called Pride, Hotel Pride, which is next to Rahul Theatre. I'd gone and watched it there. Then there was another one which I had gone and watched at this Hotel Orchid. All of them kept broadcasting it, took entry fees from us, completely illegal. But please remember, unless and until you take permission from the broadcaster, whether it is Star Sports, whether it is Hotstar, whether it is whoever else is broadcasting that content, Neo Sports, if it still exists, until and unless you're taking permission to broadcast that content, you cannot broadcast it, even for free. You cannot broadcast it. So even organizations like if you go to Boat Club and Boat Club puts it up on a screen only meant for private members who are a part of the Boat Club, even that's not allowed because broadcasting itself is not allowed. So सू किया या नहीं किया, अगेन किसी ने वायलेशन के लिए सू किया या नहीं किया, ये अलग सवाल है. थियोरेटिकली कॉपीराइट का वायलेशन हो रहा है. Does that answer your question, Nikat? So it's wrong in India also.
So it is wrong. It's just it's not enforced. That's what you're saying.
Yes.
Not a lot of people.
There are a lot of enforcements, but small clubs के पीछे कौन पड़ेगा यार? It doesn't make sense. It doesn't make sense spending that kind of money.
With the large population and how largely it's happening, not everybody can go behind every individual to just make it stop or like sue them.
आप वो गणपति पंडाल वाला example ले लो ना. Who let the dogs out? It's one of the most. It's so sad, and you've got the Ganpati on top with all his pomp and show, and then the bottom they're playing "Who Let the Dogs Out at Night." But that's literally, I mean, anywhere in Pune you go, I don't know why we're still stuck in, I don't know, whenever that song came, it's such an old song, I don't know why it's still played. Because it's got a peppy number, but then it's there. Kisne permission liya hai? I've seen everything beginning from, what is that guy?
Snoop Dogg.
No, not Snoop Dogg. I forget that guy's name. He's got a very famous, it's I think EDM, this song called Loser. I've seen it play all over Pune, yeah. Let me just remember. In any case, so electronic dance music, there are people who are appropriating content from stuff that is played in international music shows. They watch it on YouTube, they download that music, and then they play it anywhere and everywhere. No permission taken. Enforcement is very different from establishment of right. Establishment of right करना easy है. Enforcement of that right करना मुश्किल है. Yeah.
Yes, sir. And one small doubt I had when you were giving an example of Munni Badnaam Hui and the 28 other replicas of that song.
The 28 that I know of. I mean, there might be more.
Yeah. So for that, sir, just because Munni Badnaam Hui was registered legally and copyrighted and they made any other song which was released before illegal, how is that possible?
Logical.
Because you said that originality is something which is required for copyright.
Correct.
So when one song which is created in the 1900s, whatever the year, is not copyrighted and is not the registered song, how has Munni Badnaam got the copyright for it?
I keep asking the same question. It makes no logical sense.
Yeah, because then it just
the only solution, I mean, the only logical answer that I have for it is the people who have created that song prior to Munni Badnaam Hui have not filed a case. If they file a case and they say that this copyright is illegal, they'll have to go and establish the fact. But Razia Begum and the other Thumri artists are not interested. The Bappi Lahiri is not in. Bappi Lahiri has got another version of this. He's not interested. Like, मेरे को करना क्या है यार? उनको करने दो उनके. Their Munni Badnaam Hui is genuinely a very, very well-made, very what do you say, catchy.
I think it was more famous than any of the replicas before. Right. That's why it's got an upper hand for some reason.
Correct, but it still doesn't make logical sense. It's not an answer to the question. It just exists. I think if somebody files an objection to it, in all probability, there will be questions raised about the granting of the copyright and whether it should be given to that song or not. I think it would be raised.
Absolutely, sir. Thank you so much for your questions, Nikhat. We'll go on to the other students. Trapti, please go ahead with your questions.
Good afternoon, sir. First of all, thank you so much for such an insightful session. Your passion for the topic has got me excited to learn more about IPR.
Oh, great.
Sir, actually, my question was same as Nikhat. So it has already been answered about Munni Badnaam Hui's song. That you said that copyrights inherently exist. You don't need to get them registered. So the songs, there existed many songs similar to Munni Badnaam Hui before that song.
Correct.
So how come T-Series was able to get it copyrighted and other songs did not claim their rights on the song? But I think it has already been answered that they did not enforce their rights on this song.
It's about enforcement. You're absolutely right.
Yes, sir. So thank you so much.
And sir, it also becomes irrefutable at the same point of time, right?
I beg your pardon?
Sir, I said that it also becomes irrefutable for the actual creator to say that actually this creation has been done by me. How he will be able to refute that okay, that person is actually making a wrong claim and this particular creation belongs to me.
No, so Aditi, the question can be why copyright becomes difficult to establish is because आप refute तो कर दोगे क्योंकि ये exact तो मुन्नी बदनाम हुई does not exist. The similar song with the similar kind of wordings exist. Similar, not same. So what people try and say is, even though the original exists, my work is also capable of being called original because it's different. मैंने उसकी पलट बनाई है, उसमें मैंने दिमाग लगाया है, वहां पे लौंडा बदनाम हो रहा था, यहाँ पे एक औरत बदनाम हो रही है, वहां पे एक आदमी बदनाम हो रहा था, वहां पे सलीम बदनाम हो रहा था, यहाँ पे टीना बदनाम हो रही है. So I have used my brain to change something. It's not an exact replica. Exact replicas would be very easy to dismiss off, but exact replica तो कोई करता नहीं है. The music has changed, the tempo of the song has changed. अगर मैं let's just explain this to you. Let me just play this to you. Okay, that's the tempo, that's the pace of the song. Now let's go to the one of the original versions. This is the Bappi Lahiri version. Now this is the Bappi Lahiri version of it. Just let me play one more version so that you get the idea of it. This is one of the Thumri versions from long back. So there's a difference. It's not exactly the same, but the question is it different enough to be called original? According to me, no. But that will still have to be established in a court of law. That's what I'm trying to tell all of you, that to decide where inspiration is looked at very, there is no creation without inspiration. All right. If you look at any of the most famous creators, like have you guys heard this band called Led Zeppelin? I mean, it was very,
yes,
very,
sir.
Yeah? All of Led Zeppelin is copied. Whether it's Stairway to Heaven, whether it's Killing Floor, whether everything is copied, everything. There is no creation without copying. The question is, when does copying become objectionable? When does appropriation become objectionable? And what can you do about that objectionable content? So we cannot, human beings, यार आप ऐसे सोच के देखिए ना, हम हाथ पैर यूज करना सीखते हैं, फेशियल एक्सप्रेशंस यूज करना सीखते हैं, बोलना सीखते हैं दूसरे लोगों को देख के. So just to understand this, you look at a child which is born, which is blind and deaf. Their facial expressions will be very different and the sounds they are capable of making will be very different. We are able to emulate, copy sounds because we see other people speak. Little children, when they are born, they hear the sounds that are made. They observe the lip movement. They observe things that their parents and near and dear ones do, and that's how they learn. Everything that human beings do is done through copying. We first copy, we learn, and then we adapt, change, modify, and create new. There is no new creation without copying. The problem of copyright is how to justify this in a legal system which is trying to appropriate on a capitalistic regime everything for themselves and trying to monetize everything. प्रॉब्लम ये हो रही है ना, क्योंकि सब लोग बोल रहे हैं कि पैसा मिलेगा मुझे इससे मुझे और पैसा मिलेगा, अगर मैंने सबको रोक दिया इसको यूज करने के लिए तो उससे मुझे और पैसा मिलेगा. एंड दैट्स व्हाई इट बिकम्स वेरी डिफिकल्ट, because the idea of the right or the refusal of you to share your work with other people is because copyright has been used to monetize relentlessly. So let me very quickly, I'm sorry because I'm running short of time. I'll take up all your questions, but let me just address a few more points that I wanted to, so that then we can continue this discussion. And today I'm available till 2 o'clock for those of you who might want to stay back. No compulsion. You can speak to your Dr. Shariyu about it and figure out what you want to do. But let me just very quickly just put in certain things that I promised Dr. Shariyu that I'd be addressing with you. Now,
yes, sir.
Yeah. So after that, I'll take up all the questions. Okay. So
sure, sir.
This is to answer Akshat's question and Elena's question and Nikhat's question, all the questions that you guys have so appropriately put forward. There are 4 concepts that we need to understand. 2 ends of the spectrum are copyright, all rights reserved, and public domain, no rights. ठीक है, public domain में एक बार क्या चला गया, उसमें कोई right नहीं. Again, I'm talking from the economic perspective. So, copyright basically gives 2 kinds of rights to any individual. What are they? The economic rights, which are associated with exploitation of the right for gaining monetary rewards, right? And the other are moralistic rights with respect to the ownership, reputation, goodwill of the person who's creating that content. After the term of copyright gets over, the economic rights come to an end. The moral rights never come to an end. And I explained that part to you. So please remember it. Moral rights are inalienable. You cannot disassociate a creator from her creation. Not possible. Economic rights might come to an end. Not might, come to an end. Now, so the 2 ends of the spectrum are copyright, all rights reserved. In whose favor? In favor of the person who has created the content. Public domain, no rights reserved. because apart from moral rights, so I'm not talking in the moralistic sense, I'm talking only in economic side. No rights. जिसको जो करना है कर सकता है. So for example, if I want to take your book, which was under copyright, but now copyright has expired, I can take that book, I can publish it, I can print it, I can adapt it, I can make a play out of it, I can translate it into another language. I don't need to ask permission because no rights exist. Now, what if, I'm going to give you a scenario, what if I create a computer software, right? And I told you computer softwares are copyrightable because they are works of literature, literary works. I want to create a computer software, but I want to give the source code out for free. This is, I think this is in the context of what Akshat had posed as a question. And if it was somebody else, I apologize. I think it was Akshat. So in any case, the idea that I've created a software, but I want to give that source code out for free to everyone. The danger of doing this. So the only way of doing it earlier that existed was to release and relinquish all your rights with respect to that content and release it into the open market. कि मैंने उसको अपने सारे के सारे कॉपीराइट जो हैं उनको मैंने relinquish कर दिया, नहीं चाहिए मुझे, तो मैंने पब्लिक डोमेन में डाल दिया. मतलब जिसको जो करना है करो. पब्लिक डोमेन में डालने की एक खामी है. There is one disadvantage of putting it in the public domain. So let's presume that you are also a software developer. I've released my copyright with respect to it. I put it into the public domain. What you do is you pick up that source code. You say, boss, this is amazing. You make some changes to that source code. You adapt it. You make it into an app with some changes to it. But you use my source code. And then you commercially release it into the market and start making a lot of money. The entire objective with which I had released it into the market is gone now because I wanted people to benefit from it. It's a source code लो, जो करना है इसके साथ करो. मैं फ्री में दे रहा हूं आपको, लेकिन वो फ्री तो खत्म हो गया. अब मेरे क्या कहते हैं क्रिएशन के आधार पर जो चीज बनी है वो अब फ्री रही नहीं. मेरा पर्पस पूरा का पूरा सबवर्ट कर दिया उस व्यक्ति ने. To protect this, a customization of copyright started off. This was the first customization of copyright that took place, and it is only applicable to computer software. Any guesses what it is called? It's the antithesis of copyright. Any guesses what it is called?
Open source?
Open source is an application of the antithesis.
Okay.
The
freeware.
No, it's called copyleft.
Oh.
So this is the antithesis of copyright. It's called copyleft. And so copyright is all rights reserved. Public domain is no rights. Copyleft is one right reserved. It doesn't use it as a tagline. I'm trying to explain it to you and therefore I'm putting it in. One right. What is the right? You shall share as you receive. मतलब क्या है? मैंने आपको ओपन सोर्स और फ्री में दिया. ठीक, मैंने आपको ओपन सोर्स दिया, मैंने बोला इसका कोड ये है, मैंने आपको फ्री में दे दिया. आप भी इसके अंदर से जो भी डेरिवेटिव वर्क करेंगे उसको फ्री और ओपन सोर्स ही करेंगे. शेयर अलाइक, शेयर एज यू रिसीव. ऑलराइट, वन राइट रिजर्व्ड. इज दिस क्लियर? शेयर एज यू रिसीव्ड, शेयर अलाइक. इफ यू हैव रिसीव्ड इट open source and free, you will pass on any derivative work that comes out of the work that I have created, also open source and free. That's a contractual obligation on you. Otherwise, I will sue you. Okay. And you sign that contract while using my content. Okay. Did you understand here? Till here, are you with me? I'll give you an opportunity to ask questions, but are you with me?
Yes, sir.
Then they thought that if we are applying this concept to computer software, why not expand that idea and apply it to literally everything else? And that's where came about the biggest revolution to the idea of copyright, which you guys need to be aware of. It's called Creative Commons. CREATIVE COMMONS. Creative Commons. Now, what is Creative Commons? Creative Commons is some rights reserved, which basically means that you as a creator, Elena, you told me that you create music. You as a music creator can decide what you want to do with this music what kind of usage you want to allow of this music for anybody else, right? That's called Creative Commons and customization of copyright for everything else apart from software. And the tagline over here, it's some rights reserved. And which these some rights are is up to you. So in terms of the ascending order of exercising of right with respect to artistic content, the least severe is public domain, no rights. Then is, in that order, is copy left, which is one right reserved. Then is Creative Commons, which is some rights, and then is copyright, which is all rights. So from all rights to some rights to one right to no right. I'll repeat myself. I'll repeat that order. Public domain, no rights. Copy left, one right. Share alike, share as you receive. Creative Commons, some right. Some right means you can customize it to one right, or you can make it extremely severe. You can do whatever you want to it. You can customize it. And copyright, which is all rights reserved. Now, Varun, I've sent you a link. Would it be possible for you to show it and share your screen and put it up online? Will that be possible?
Sure, sir.
Yes,
Just a minute. Just a minute.
Please, if you could just show it. I'm trying to give you certain details about Creative Commons and tell you certain details on how to go about exercising your rights as creators in this field with respect to using Creative Commons to apply for licenses on your own without any external help. So that's what I'm trying to take you on to. Varun, whenever you're ready, please share the screen.
Yes, sir. Just a minute, we're on it.
Oh, no hurry, Aram se. In the meanwhile, does anybody want to ask a question?
Sir, I believe Trapti
Yes,
has a question. Rohan, okay, Rohan, go ahead.
Go ahead, Rohan.
Yes, sir. Thank you for the session. It's been really nice hearing you. My
Thank you,
attention span is really less, but with you, I think it's a little longer today.
Yes, I apologize for that.
So I had like a couple of questions. One question was that, sir, when we upload a piece or anything on YouTube, so does YouTube provide you a basic copyright to that? And if it does, the copyright, does it belong to then YouTube or does it belong to the creator itself?
No. YouTube is just a hosting service provider. They don't own your content. It does not provide you a copyright. It is just a sharing network.
Okay. And sir, and the second question I had was that, sir, if suppose like there's a TRIPS agreement and like if there is a product that you suppose patent for, okay, or like a technology you patent for, and suppose that product, which in the end product which you get out of it is legal in one country and illegal in another country, and you have like a multilateral agreement, like how you told about TRIPS agreement. So how does like those type of products work? Like does the patenting for this product still be applicable to those countries too? Or
No, that a very, very good question, Rohan. So let me give you an example. There was a software, artificial intelligence based software called DABUS. I don't remember. It's an acronym. I don't remember what the full form of DABUS is. It was granted in South Africa, which is a signatory to TRIPS. It was rejected in England, which is a signatory to TRIPS, and we are not even willing to consider the question. So the application of these laws also still vary from country to country. ऐसा नहीं है कि क्योंकि हमने TRIPS sign कर दिया है तो सारे के सारे decisions with respect to progress of science and technology in the field of various forms of intellectual property will follow a uniform trend. What can be patented and what cannot be patented is still something that is up to individual legislations. Like, for example, we have for the longest time resisted the idea of patenting of life forms. We don't think life forms in India, we don't think life forms should be patented because it's natural. So there is a difference. इसका ये फर्क, ये अंतर और ये जो भेदभाव है दोनों legislations के बीच में, वो हमेशा exist करेगा. It will not any time become common. What is the commonality which is trying to be achieved through the TRIPS agreement is conceptually they should all be similar. तो अगर एक country में, for example, copyright is given for example, India में copyright is given for lifetime of author plus 60 years starting from the year consequent to the year of death, which basically means सोच लीजिए कि मैं एक author हूँ, मैंने सन 1985 में 85 में एक किताब लिखी. I have written a book in 1985 and it's published. I die in the year 1999. Okay. Basically then, for my lifetime, which is 1985 to 1999, the copyright will exist. And the copyright will then continue to exist from the year subsequent to the year of death, which will be 1999 pura chalega, 2000, including the year 2000, for 60 years, which will be 2059, December 31st, tak mera copyright rahega. It will last for that long and it will be exercised through my legal heirs. Now, this is a concept that was created through TRIPS and it is uniformly applicable all over the world. Some countries have it at 60 years, some countries have it at 70 years. But I think the standard laid down by TRIPS, if I'm not wrong, was 60 years. And we've adhered to that standard. We can't go below that. We can't say that we will provide lifetime of author only, no protection after that. We can't do that. So those are the kind of uniformity that agreements like TRIPS are trying to bring about. I hope that answers your question, Rohan.
Yes, sir, it does. And so like all the authors are like all those famous poets and writers who had been in like suppose in years like 1500 and 1600s, all their works, sir, they'll obviously be safeguarded by some institution of that sort, right?
Correct.
So
but they're free
like,
from copyright. They're free from copyright now.
So what about if one of them has if they have a legal heir to the to these
moral
people?
Rights can only be protected now. So if there is some author from the 1600s whose work is going to be used, then they're going to turn around and say that financially you cannot protect it, but morally you still can. Let me give you an example. The original works of Socrates can't be protected through copyright financially, but they can be protected morally. If you look at the book written by this one of the last famous Roman emperors called Marcus Aurelius, basically Stoicism, from which the modern word meditation emanates. His works were called the Meditations. Now they are available. And thankfully, they've stood the test of time and they've been translated into English and they exist. That translation, nobody can stop. You can translate it into Malayalam, Hindi, Urdu. You can pick up his Latin works and translate it into whatever you want to. Nobody can stop. Nobody can say, don't make money out of it. Penguin can publish it. Forget Penguin. I can publish it. मैं कल को खुद छाप दूंगा उसको पकड़ के. कोई नहीं रोक सकता मुझे. Does that make sense?
Yes, sir, it does.
Yeah.
Sir,
Okay.
is this
Thank you,
screen
sir.
visible?
Yes, the screen's visible. So let me just quickly show you around this content and then I'll take up more questions. Now, can you scroll down a little bit? So this is use Creative Commons tools to help share your work. Our free, easy to use copyright licenses provide simple, standardized way to give your permission to share your work and use your creative work on conditions of your choice. You can adopt one of our licenses by sharing on the platform or choosing a license below. So you decide to share your content online on your own without any interference by a lawyer. And this will be enforceable in India because this is created out of a contract which is based on copyright law. So all you need to do is choose the features, decide what the optional info will be and get the license. And I'm going to tell you how to do it. Just scroll up a little bit, Asta. No, scroll up, not down, scroll up. Yeah, can you click on CC licenses and examples, please? Yeah, scroll down. Now this is where the versions of CC licenses come up, and I'm very quickly going to go through it. CC only stands for, can you see the logo on the left hand side? Now, as soon as you get a license, you get an image. You can embed that image into your content, or you can put it up on the website. You see this image. Asta, could you do me a favor also? Can on the next tab, can you open up Wikipedia, please?
Sure, sir.
Such nice chai. Now, type in, for example, type in Creative Commons. Just type in Creative Commons. All right, just click on that. On anything. Yeah. Now, this is what Creative Commons is. Scroll to the bottom of this page, right to the end of the page. Now, the entire Wikipedia project in itself is run on Creative Commons. Can you see the just below? If you see, this page was last edited on 22nd January 2022. Can you see that part? Yeah, below that, see. Text is available under Creative Commons Attribution Sharealike license. Additional terms may apply. By using this site, you agree to the terms of use policy of Wikipedia. So even Wikipedia is a Creative Commons, is the application of a Creative Commons license. It's a public encyclopedia. So what they are saying is, now let's go back to the original page. Now over here, could you increase the font size a little bit? Just do Control++. Actually, I don't know what device you're on, so please just increase the font size a little bit. Yeah, that's great. That's great. Thank you. Now, if you see the image on the left hand side, you see a CC within a circle, which stands for Creative Commons. And then you see a human being with a circle around it and by written over there, which basically means this is the easiest and the most least restrictive form of license you can create. This is called an attribution license. The only requirement is to attribute the person who's created the content. Nikhat, this is the answer to your question. So if the only requirement that I have from a creation that I have made is to release a video under an attribution license, all I need to do is get this license and release my work under this license. Then the only obligation on the person using this content would be to say that this license has been, this content has been created by Nikhat and I am using it. That's all they'll need to do. All right. Now, can you see this license allows reuse, distribute, remix, adapt, build upon the material in any medium or format so long as the attribution is given to the creator. The license allows for commercial use. So the other person can do whatever they want to as long as they attribute you for their creation. Now, could you scroll a little bit more? Now, the next one becomes a little bit more restrictive. This is, can you see CC BY SA? What does this stand for? This stands for Attribution Sharealike. This license allows reusers to distribute, remix, adapt, and build upon the material in any medium or form so long as the attribution is given to the creator. The license allows for commercial use. If you remix, adapt, or build upon the material, you must license the modified material under identical terms. What does this mean? So this license allows you to do it. To allow other people to use the content. But if the original creator has used these two symbols, that means any derivative work that you create must also be created in a similar manner that your work should also be allowed to be used by other people under a similar license. Am I making sense? So credit must be, what does this mean? Credit must be given to the creator. Adaptations must be shared under same terms as in which you have shared it. You have received it. Share alike. Okay. So now scroll down a little bit more. Now, this is non-commercial use. Here you make the license a little bit more restrictive. Now you are saying, I am going to give you you must give me the credit. You can use the work as long as it is not for a commercial purpose. So you can use it for academics, you can use it for research, you can use it for anything as long as you are not making money out of it. So this is a restrictive license which does not allow commercial use of it. Now go down more. Now this is even more restricted. This is attribution, non-commercial share alike. That means you will have to create what. So अगर सोच लो आपने commercial share alike किया, नॉन कमर्शियल एट्रीब्यूशन किया. अगर मैंने आपके काम पे कुछ डेरिवेटिव वर्क आपके काम से बना के मैंने यूज करके कुछ बनाया है, आई कैन अलाउ अदर पीपल टू डू वट एवर आई वॉन्ट टू एज लॉन्ग एज आई कैन अलाउ कमर्शियल यूज ऑफ माई वर्क. बट if this person takes the share alike one, then even I can't allow it. So it makes it even more restrictive. Credit must be given to creator only for non-commercial uses of the work, and adaptations must be shared under the same terms. That means when you share your work, it will also have to be, credit must be given, and it can only be non-commercial. You cannot allow commercial usage of that work. Scroll down. I think there should be one more license if I'm not wrong. Now, this license is even more restrictive. It says no derivative work. मतलब आप मेरे काम को हूबहू वैसे का वैसा यूज कर सकते हो, उसको कुछ चेंज नहीं ला सकते. अगर आप उसको मॉडिफाई नहीं कर सकते, चेंज नहीं कर सकते, अडेप्ट नहीं कर सकते, कुछ नहीं कर सकते. यू कैन यूज इट as I have given it to you only. Now, again, then this goes into non-commercial, no distribution. Then it goes into, then the share alike model will come into this version also. Just scroll down. This is similar kind of ideas. So now you've understood. Non-commercial will be a dollar with a symbol across it. Equal to will be no derivatives allowed. Human being will be what do you say? Attribution. Share alike will be SA. They'll mention all these things. Just scroll down. There should be. I don't think there's any other complication over here. This is the public domain. Can you see 0 with a this thing against it? You can release the content in public domain also. I said I relinquish all copyright. I don't care who does with it. I can relinquish it, and that will be the license that you can release it under. Public domain. Okay. So these are the different kinds of licenses that you can get. You'll have to sit down and explore these kind of licenses. At the bottom of this page also you'll see how to choose a license. They help you decide how to choose a license also. Okay. Now, could you scroll up, Asna? Yeah. Can you click on थोड़ा सा टॉप पे जाओ, वहाँ पे share your work वाला ऑप्शन पे फिर से क्लिक कर दो प्लीज. Now scroll down. Scroll down a little bit more. Let me just find that कहाँ पे है. Share your work. थोड़ा सा और. These are the places where you can share your Creative Commons licensed works. But the question is not that. The question is how do you get that license? And I'll take you to the correct page. If you want. Asfa, could you share the link of all of this with all the participants so that they know how to go about doing it?
Absolutely, sir. We'll do that.
थोड़ा सा और नीचे scroll down करो. In the Commons. ये बड़ा नहीं था. Let me just open up my page. Just give me 1 second, please. Choose your license. No, not this one. Standard. If you scroll to the top of the page, Astha, you'll see an option called Places to Share. On top of this page itself, can you see थोड़ा सा नीचे जाओ, थोड़ा सा नीचे on the right hand corner in this section, can you see Places to Share? Yeah, please click on that. Now this is where I'll tell you how to go about sharing your work and where all you can share it. 2 billion, नीचे जाओ. थोड़ा सा और नीचे. Content collaborators. Yeah, 8 minutes. 8 minutes. Obviously, I've made a mistake. 1 second. I'm so sorry, Astha. Can you go back to that tab of share your work? Share your work पे चले जाओ. After you go on to share your work, scroll down and click on get started in that blue tab, in that blue box. You can see the word get started. Just click on that. Now, अभी थोड़ा scroll down करो. Now over here, you will be able to, ये सब है. You can, the choice, the questions are going to be asked and all of that. Commercial use, yes, no. Select the license, yes, no. ये सब आपको एक option मिल जाएगा समझने का कि ये कैसे use करना है और इसको apply कैसे करना है. Scroll down a little bit more. थोड़ा सा और. Now learn how to share your work with existing communities. Now, अगर आपने music create किया है, Elena, if you've created some music and you want to share it and you want to release it on a particular license, how do you go about doing it? Now, how to share your work with existing communities? Click on that. It's a Wikipedia page which will open up. This page is very important, Asta. Just share this link with everybody, huh? This one is extremely important. Now scroll down. Now it depends upon what kind of work you have. So if you've got an image, if you've got an audio file, if you've got a video file, if you've got a text file, whether you've written a book, a poem, a video, a sound recording, an image, photograph, anything, how do you share it? So since Elena had asked a question about music, let's click on audio. Now, these are the places where you can share your content, and for everyone, they have created a how to publish your content on that particular sharing platform. Now, whether it's Jamendo, whether it's SoundCloud, Internet Archive, all of these, they have shown you how to go about releasing your content on these sites. Now, if you want to release it on other sites, you just have to go back to the main page, follow their step-by-step procedure, and embed that content into, for example, YouTube. There is a video that has been created on how to upload Creative Commons content onto YouTube. I'll send you the link for that also after this lecture gets over. So it's very, very simple to do, because, for example, if you click on SoundCloud, just click on SoundCloud, wala, how to publish on SoundCloud. No, how to publish on SoundCloud. Click on. Very simple procedure. It's extremely simple. After registering an account, select upload or share from the top menu and go to SoundCloud, upload your track, then select the CC license. And this will be the CC license. You'll just have to decide आपको attribution चाहिए, नहीं चाहिए, commercial चाहिए, नहीं चाहिए, derivative चाहिए, नहीं चाहिए, share alike करना है, नहीं करना है. ये सारे choose करने के बाद, you can also change your default licenses. There are extra options available. If you don't want to keep it complicated, you can just say attribution, share alike or whatever, and then release that work. That's all you need to do. It's that simple. Okay. How to upload Creative Commons content onto YouTube. I'll just find that video and send it across. So it's not a very complicated procedure. All you need to do is upload the content, choose the kind of license that you want to create for it, and release the content as you want. It would be easiest to try and do it. Click a photograph from your phone and try and upload it onto Flickr, for example. If you go onto that image wala part, it has options of which websites you can release it onto, Flickr being one of them. Okay, so this is basically how you go about releasing content, getting your own copyright, releasing your own content under a copyrighted license, and making sure that your content is compliant with copyright on your own without hiring a lawyer, without going through the complexities of understanding the nuances of contracts. It's very simple. It's very easy. It's used the world over. I would encourage you to use it. And in case you have any questions on or queries on how to use it, you can always reach out to me and I'll be glad to assist you in that regard. Now let's take up the questions very quickly.
Sir, we are very sorry, but we have lectures now. Some students have lectures, so we have a provision in the feedback form where all the students can put their questions in. We'll communicate the same with you and then get back to everybody. We're very sorry about this.
Perfect. Thank you so much. Thank you so much, Asta, for helping me coordinate this. Thank you.
All right. Thank you so much, sir. It was an absolute privilege to have you here with us today. I would like to I'd like to invite Dr. Swati Chine, ma'am, the head of Department of Business Laws, for the vote of thanks.
Good afternoon, ma'am.
Good afternoon. Good afternoon, everybody. Good afternoon, sir. So, on behalf of the Center for Innovation and Entrepreneurship and Department of Business Laws of our college, I, Dr. Swati Chine, Head of Department of Business Laws, really take pride to thank you, our very own Mr. Gokul Narayan, sir, for readily accepting our invitation to come as a resource person for this workshop and for sharing his expertise on IPR with us. Sir, you have simplified and introduced a very complicated and vast topic of IPR in a very lucid manner by giving a bird's eye view of the entire topic and by giving n number of examples, relevant examples, I would say. So your valuable inputs will be useful to all of us in understanding and applying intellectual property rights in the digital era. We look forward to many more such lectures and inputs from you on various topics of interests of the student. Thank you, sir.
Thank you, ma'am.
I also take this opportunity to thank the RUSA authority, that is Rashtriya Uchchatar Shiksha Abhiyan of the government, who is the funding authority for this present workshop of 2 days. A big thank you to our RUSA coordinator, who is also our IQAC head, Dr. Anil Adagle, for helping us through the RUSA procedure. Thank you, sir. I would like to also thank our enthusiastic, encouraging, and ever-supporting principal, Dr. Soman, sir, our inspiring teacher, Vice Principal, Dr. Tesi, madam, all faculty members, various department colleagues, our Registrar, Parulekar, madam, and her administrative staff for their support and cooperation for organizing and executing this event. We owe our thanks, special thanks, to our librarian, Mrs. Vaishali Vaidya, madam, for designing the certificates of this workshop and digitally connecting them with the feedback forms. I also thank all the organizing committee members of Department of Business Laws and CIE, especially Dr. Sharayu Bhakre, madam, who is the backbone of this workshop and head of the CIE Center, along with Dr. Nilesh Wagmare, sir, and Sarika Wag, madam, for planning and execution of this workshop. Thank you, Sharayu. I also want to thank the network administrators of our college, Mr. Nazir and Nitin, sir, for their technical help. उनकी वजह से आज actually सब हम मिल रहे हैं, देख पा रहे हैं और सुन भी पा रहे हैं. Thank you, Nazir and Nitin, sir. This event would have not been possible without the support of our ever enthusiastic student volunteers team of Varun Deshpande, Atharva Tidke, Divyanshu, Manish Agarwal, Asta Kumar, Varun Mohan, and Gautami Rani. Sorry, students, if I have missed out anyone's name. And last, but certainly not the least, how can I not thank the attentive audience of this workshop? You students were really very much attentive, enthusiastic, and eager to ask intelligent questions. So thanks to each one of you, my dear students, for participating in such big number till the end. And I declare this workshop is at an end. Thank you one and thank you all. Good day. And I request all of you to give a big round of applause to Gokul Narayan, sir. Thank you, Gokul, sir. Thank you.
Yes. You can make the announcement maybe now.
Yes, ma'am. Guys, the feedback form has been uploaded in the chat box and we will be displaying the QR code for the same. Please do make sure to fill the form so as to avail your certificates. Thank you so much, sir. Thank you, ma'am.
Yes, thank you. Thank you.
Thank you, Gokul, sir. Thank you so much. Thank you, Swati, ma'am.
Yes, thank you. Thank you.
The forms will be open for 20 more minutes, so please make sure that all of you fill it to avail your certificates. And if you have any questions, please make sure to put them in the form.
Sherry, ma'am, could you please stop the recording? The organizing team is requested to stay back for a photograph.